All rise for the jurors. All jurors are present and accounted for, Judge. You may be seated.
All right, we'll get the most popular question out of the way first, Doctor. Explain to the jurors, if you know, whether alcohol consumption has any effect on RBD and also confusional arousal. Let's do it in that order.
Right. So basically, that's been an area of controversy in both editions of the International Classification of Sleep Disorders. The short answer is it hasn't been studied formally. In other words, giving people fixed amounts of alcohol and measuring, things. But in both versions, it says it's hard to make a diagnosis of that in the presence of alcohol. It doesn't say how much alcohol.
So if we make it a more generic question, not specific to RBD or confusional arousal, and instead I pose the question, does alcohol consumption have any effect on the sleep behavior of a person?
Well, in terms of, it makes sleep a little bit more fragmented. Movements occur more often in terms of just clinical judgment as opposed to really good data. REM behavior disorders more frequent and more intense with alcohol, just sort of not studied in any intense way, but just clinical impression. What has been studied is movement in sleep is worse with alcohol. Not necessarily behaviors, but more movement.
That's your answer. Would fatigue from physical activity, for example, playing 18 holes of golf in hot weather, affect one's ability to sleep or the time for them to reach deep sleep?
I don't think there's enough scientific data to make a comment on it. It makes sense that it might. Fatigue, as I mentioned or alluded to, is a very difficult construct physiologically. There's like 11 or 12 different scales for fatigue, and the only reason there's 11 or 12 rulers is because we don't know what we're measuring. So it's very hard to extrapolate fatigue to sleepiness.
For someone who's been diagnosed with RBD, is there any medication that is commonly prescribed?
I previously mentioned that there's 3 groups. One is probably the best studied, or it's not great data, but melatonin, which you can get over the counter, not regulated, so we don't really know. Also, a long history, but not studied very well, in clinical use has been Valium-like medications. And then the third that's been looked at, and this is sort of more related to the fact that in many instances, the natural history of REM behavior disorder is progressing into a neurodegenerative disease, most likely in the Parkinson's disease area. Medications that are used to treat Parkinson's disease have been used as well.
Do you know if Mr. McIver was taking any of those medications that you described, those 3 categories, by the time he was seeing you?
No, he was taking none of those when he was seeing me.
Do you know from your review of the medical records that you were presented with, if he had ever been prescribed and had taken any of those medications?
He had been prescribed melatonin, and well, as I said, it's available over the counter, so you don't necessarily need a prescription for it, but he was prescribed melatonin by physicians at the Mayo Clinic, and as I recall, he did not take it there because the impression I got was his interpretation that they told him, we'll take 3 or 4 of these tablets, and it just seemed excessive to him. And indeed, melatonin is used at very high doses to help with REM behavior disorder. We don't understand why it works. So a typical tablet in the store is 3 milligrams, which is kind of super physiologic for what it's intended to help with. So people often take 4 of them, 3 or 4. So he was like, whoa, I don't get that, right? And then he was also, I think he actually took a Valium-like medication for a little while and found that he was having hangovers the next morning and didn't take it for a long period of time.
Did he place either of those courses of treatment, taking melatonin briefly or Valium light, chronologically? Was that 2010, 2004?
This was back in 2007, 2006, 2007, I think. And he did melatonin first, I think, because you don't have that grogginess, hangover effect, and it's natural and over-the-counter medicine.
Did Mr. McIver relate to you any cautions or restrictions that the Mayo Clinic professionals shared with him based on their diagnosis that, well, this means you shouldn't drive or use heavy machinery or anything like that?
Nothing like that, but I seem to recall them advising him not to ingest large quantities of alcohol. I think that was sort of brought up relevant to the first question that was asked. Might make it worse.
Were there other treatments recommended beyond the types of medications you described that would have addressed the diagnosis from the Mayo Clinic? A CPAP machine or sleep aids or anything? That may not be the right thing.
Yeah. So basically when people are seen and they have the sleep study, it's also, a lot of what we do is rule out other disorders. He did not have sleep apnea anywhere close to it, so that was not an appropriate treatment. My other comment that I think that's getting directed at is the treatment, is it going to help, and is it going to help what aspect, right? Is it just going to get rid of the behaviors in sleep? Or given this fact that I told you, you just don't put on a disease at night and take it off in the day, or have it in the day and take it off at night. Diseases are 24-hour critters. And we don't often, as treating physicians, unless you're a sleep physician, treat the patient holistically over 24 hours. So when you're asking a question, and we're treating REM behavior disorder, maybe I can get rid of the behaviors at night, but all the accoutrements of daytime that may be associated with it or have been, don't know, right? Those aren't usually the outcome variables. Is that?
That's your answer. Thank you. Including the word accoutrements.
I can't spell it though.
Tell the jurors what an age-matched control is.
Yeah, so essentially if you're going to do a study in a group of people or about a certain disease, let's say narcolepsy, let's just keep it outside of this. So narcolepsy starts in your teens, usually, and in your young 20s. So if you're going to compare how those people are affected or anything about those people, you don't want to compare them to 40-year-olds. You want to compare them to like-minded, people that are teenagers or 20s that don't have narcolepsy. So age-matched means you try to match the age to the patient and sex. Sex is a big effect on all these factors. So you want a sex and age match to the population that you're studying. So in this instance, when we did when I was talking about the muscle movement, that's what we did. We took patients diagnosed in the clinic that had REM behavior disorder and then compared them to people that were of similar age, not statistically different, and say what's different.
Did you testify that there haven't been studies or many studies on folks who are 70 or above?
In general, for sleep apnea, I was using it as an example, but it's always a problem both ends of the spectrum in terms of having a good distribution of very young patients or very old ones that are included. I mean, most studies just include 20, adults.
So are there age-matched controls for folks in the, let's say, 70 to 80 band?
Well, for our study that we did relative to RBD, yes.
Okay.
For REM behavior disorder, yes. I was referencing sleep apnea, for example, as past 80 is unclear how much benefit.
From the records that you were provided to review, did you come across any other diagnoses or medical care or treatment for Mr. McIver post 2008, the sort of end date of what you were saying the Mayo Clinic records were?
Not so much. I mean, he had some of the routine things done, like a colonoscopy, sort of health maintenance type issues, but no other really significant diagnosis.
And between the sleep evaluation that you identified from the Mayo Clinic records and the sleep evaluation you conducted in 2017, any evidence you were given records showing that there had been another sleep evaluation between the two?
No. Caveat. So he had an in-laboratory study in, I believe, 2004. So that's under observation with all the detail that we can get out of a polysomnogram. I think in 2009, because this issue was continuing, maybe getting a little worse, they figured, well, it's hard to justify a whole nother lab study, so let's do a home sleep test, which only specifically looked to see if he had any alterations in breathing. So not all the leads, just could this have occurred in the interim at the Mayo, and they didn't see anything indicative of that.
So then 2009 we get to 2017 in your evaluation.
About 2018.
2018, sorry. Okay. Your attention was drawn to several questions on one of the questionnaires about sleepiness level or likelihood of falling asleep while being in a car at an intersection or an hour-long drive.
Yeah.
Do you know if those questions were posed in the context of the person answering is behind the wheel, as in driving, or is simply in the vehicle?
There's two questions. One is related to, I think it actually specifies driver while stopped at a red light. The other one is phrased as a passenger in a car. I think they're two separate questions.
When you were developing your ultimate opinion as to what conditions Mr. McIver suffers from, how would you describe to the jury the relative weight you placed on self-reporting from Mr. McIver versus the clinical data that was gathered either through your 2018 evaluation or records that you had?
So can you...
The relative weight you gave to anecdotal information provided by Mr. McIver.
Yes.
I did this, I felt that, versus the data gathered through your evaluation and whatever may have been in the medical records.
Yes, I would say more, probably 75-80% on the latter, as opposed to my personal evaluation of him, I guess. Let's not put a number on it. So a lot of it comes down to what was seen on the sleep study and his history and past history, and I mean the whole thing together, I guess.
So did you put more weight on the self-reported?
What I put more weight on was what data hard data that we had, and I think the diagnosis of REM behavior disorder is solid. Taking it, then a lot of weight on what is not so much weight on his story, because we went through some of the details being cloudy, and but also the repetitive nature of them from naps that he reported on weekends at home, where he'd wake up frequently not knowing where he was or startled. And then also the literature in my clinical experience of like patients. So for example, REM behavior disorder patients that oftentimes will come to the clinic, and you almost know what the diagnosis is, not in this case, but in many others, the family members come. And I can almost know what the diagnosis is because the family members are there to speak to the variation in the level of consciousness that the patient sitting in the room has. Oh, I don't want dad to be considered normal. I want to make sure the doctor knows that this is a fluctuating situation and he's only getting a snapshot of 20 minutes in the clinic. So, I mean, that's not an unlikely scenario, for example, in many other patients with that diagnosis.
Do the symptoms of REM behavioral disorder manifest primarily during deep sleep, or can they show up during lighter sleep or brief nap?
Well, they occur The short answer is they can occur in all, but there is, by definition, they occur in dream sleep. If you look at patients that have been described by the group at Barcelona, the group in Helsinki recently, large groups of patients with Parkinson's disease and REM behavior disorder, they also have sleepwalking and other behaviors that by definition come out of non-REM sleep.
When was confusional arousal identified as a known medical condition? Are you able to put a date or a date range? 1800, 1900?
Well, the phrase sleep drunkenness goes a long way back, and in as much as the International Classification of Sleep Disorders 2 uses those almost synonymously with one another. In German, it's Schlafkrankheit. Icelandic, Schwindrunki, so all
The co-reporter's loving all the foreign words.
we can spell the Icelandic. So different cultures have had phrases for it. Actually, scientifically, I don't know actually who first. Not my, ultimate area of expertise.
But is that a concept, even if we call it sleep drunkenness, that
Yes.
was being
Been
discussed?
around for 100 years.
Okay.
Or more.
I didn't hear you.
100 years or more. How to measure it's really the challenge.
Were there any other instances of possible confusional arousal that Mr. McIver shared with you during your interactions with him beyond the incident,
Yes.
September 25,
Yes.
that brings us all together?
Yeah, so that's why I was getting to these naps. He said he would take naps on weekends frequently. And because he wouldn't do it during the week in front of, with his employees around. And he sort of described several times being startled awake by noises, or he couldn't get into a lot of detail about these when he was in his home environment. And I really tried to get him to be more specific, and that's was a little frustrating, and you don't know how much of that is amnesia. What I was sort of really wanted was an observer to sort of help with that a little bit, getting to the,
Okay. Were you paid, or was the clinic paid for the examination, the work that was done earlier this year?
So he was seen as a standard patient in an outpatient setting and sort of billed to insurance as opposed to, and then separately from that, an opinion was separate.
Okay. Do people typically have significant shifts in sleep patterns after a traumatic event? I know that's an adverb in there, but is it typical for that to happen? Is it traumatic?
Well, there's the whole literature about post-traumatic stress disorder related to traumatic events, which is not my area of sub-expertise that I can get into. I guess one of the things on the differential in this instance, given Mr. McIver's involvement in my understanding of what he told me in Vietnam, was whether some of these behaviors at night were really sort of a manifestation of post-traumatic stress disorder, but his descriptions of the content and others in both the record from Mayo and ours didn't suggest that they were flashbacks or related to military.
Have you ever worked with a patient who was ultimately diagnosed with a sleep disorder who acted so violently during some manifestation of that disorder that he or she actually killed someone else?
No.
Are people able to talk during instances of confusional arousal?
Mumble or occasional word that comes out. I mean, a lot of times with it not in necessarily this demographic, but a lot of our patients will, that have hypersomnia, that have sleep drunkenness, will have discussions with a bed partner or a spouse and have no recollection 3 hours later of any of the content.
Can one experience more than one confusional arousal incident in a short period? 5 minutes later you have another one, or doesn't?
I don't think there's literature on that, and I did not run across anything. I think that's a great question.
Could be a new paper.
Too many to read already.
Do you know if your patients are tested for any sleep medication before they show up for a sleep study?
I know the answer to it. I'm just trying to think of how to phrase it. So usually if we test for that, we test for it on the backside, so the morning after, or the day that they're getting tested for how awake they are, because it's more usually typically a question related to, does it affect the results of that as opposed to the sleep study. And those, in many instances in most labs across the country, are old-time tests that don't pick up a lot of the new medications, and so unless you specifically ask for it, it's not done.
Okay. So a related question, is it possible for a patient to control or influence the sleep test outcome by withholding information, taking sleep medication that's not detected, etc.?
I don't know about withholding information. I'm not sure where that's specifically going in terms of a false positive or false negative result, but medications-wise would be the biggest issue. And we just don't test for it frequently. I think about it myself, theoretically. In fact, in this instance, Mr. McIver was taking tamsulosin for BPH, right? And I looked up literature to see if there was anything published on the potential interactions of that drug with anything in sleep. There's really no literature on that, and also just from a theoretical basic science background, kind of considered it and looked at it compared to a similar drug. For example, it would be prazosin, used old-fashioned drug used for blood pressure years ago. And if anything, theoretically, hypothetically, that medicine might be expected to help his increased muscle activity, but there's no data.
Is it possible for one to fake falling asleep during a sleep study, or do all the different sensors alert you to the fact that even though the eyes are closed and there's a snoring noise, that person's not really asleep?
I touched on that a little bit. I'm sorry I didn't answer it when you asked previously, but the short answer is no. There are people that have misperception issues. Different ways to define sleep: behavioral, just watch you, and you could sort of say, well, what's that? How do I know they're asleep? Well, they don't respond to a stimulus, auditory, touching, whatever. You'd say, oh, they're not moving. That's behavioral sleep. As opposed to what we do, which is measure brainwave activity and output of the nervous system, which essentially tells you that the state of the body and the brain is sleep, essentially. So some people may misperceive that. They may wake up and say, no, I didn't sleep at all. I remember one guy that came all the way from India to see me who claimed he never slept. He slept beautifully under video camera, brainwaves and everything. Came in the morning and said, how was your sleep last night? He goes, I never fell asleep. So there are those rare examples, but you can't willfully do it, that we know.
Are there any external factors or stressors in someone's life that could affect the results of the kind of study Mr. McIver underwent under your supervision? And if so, what are the types of stressors or external factors?
I think our understanding of those is really paltry compared to, say, medications, and that's even paltry. So you're measuring a lot of variables, and we understand it's complex, it's affected by a lot of things, and that list is very long. And we just haven't gone through it.
Okay. Ms. Clark-Palmer, do you have any follow-up based on those few questions?
It will be brief, and I will make a promise about that. Dr. Wright, I know you told us about, you were asked how much you have gotten paid, and you explained about insurance. But just what's the total amount that you have received or have invoiced for your services in this case?
$6,000 or $7,000.
Okay.
Dollars.
Okay. And you were also asked a question about whether Mr. McIver had tried any kind of medication, and you were recalling that the records said something about him trying melatonin. if you need to review the records to refresh your recollection, let me know.
That's in the Mayo Clinic thing, I'm going by memory. There were almost 400 pages.
Okay, so I'd like to show you some pages to see if it refreshes your recollection that he tried other medications as well. So first on page 86, reading this sentence.
Yeah. So it says that patient has been unable to tolerate an adequate dose of clonazepam, which is a Valium that I mentioned. I just used Valium because I thought the jury would be more familiar with that. He was also tried on melatonin up to 12 milligrams a day, so he actually did take it. So the 3 milligrams times 4 tablets. Up to 9 milligrams was not effective.
And also on page 141, what's that last one?
Oh, Rosarim, which is a melatonin-related drug.
Okay, all right. So
That's actually, pharmaceutical grade kind of agonist of the melatonin receptor.
fair to say that the medical records, according to the medical records, clonazepam and melatonin were tried and appeared not to be successful.
Yes.
All right, thank you.
Mr. Abate, I agree as well. Dr. Rye, I'm prepared to say though, from the years 2009 to 2018, when you saw him, Mr. McIver wasn't taking any medication for his alleged sleep disorders.
Correct.
And you talked a little bit about the effects of alcohol. Isn't it true that alcohol actually delays someone from entering into the dream sleep or the REM cycle sleep?
I don't think it does it 100% of the time, but that's what you would suspect, yes.
Okay. And if you're not in REM cycle sleep or dream sleep, you can't have, or it's less likely that you're going to have an RBD or a REM behavioral disorder episode, correct?
That's what you would expect, yes.
And you talked a little bit about these naps that Mr. McIver would describe on the weekends, and you take a nap and hear noise, you'd be startled. Is that what you said?
Woke up and I'd say, were you dreaming about anything? I can't tell you. Can you remember what made you wake up? No, I was startled awake, and I thought I was sleeping because he knew when he had started the nap, for example.
And with those naps that he described to you on the weekends, did he report shooting anyone when he was startled?
Didn't report any further details.
Okay. And you talked a little bit about, when answering the questions, about some of the factors that, I guess, could cause someone to experience a RBD episode or confusional arousal. I think you referenced fatigue when the judge asked you the question. You weren't in the car on September 25th of 2016, correct?
No.
And another explanation for what happened in that car could be that Mr. McIver was awake when the gun went off, and confusional arousal and RBD had nothing to do with it, correct?
It's a possibility.
It's just as possible as that he was suffering from RBD or confusional arousal, correct?
Sure. I mean, there's lots of explanations.
No further questions.
Doctor, thank you for your time. Appreciate it. Thank you. We may need to get the spellings of those two words at a later date, but I won't hold you to that. Icelandic. Defense?
Our next witness is Stan Smith.
Okay. Did you all talk more about Mr. Smith, or should we have the jurors take a quick break? The latter? Okay. Ladies and gentlemen, we need to have a brief conversation before Mr. Smith can testify. We didn't have time during the last break to get to it because you had that nice deck of cards that you sent my way. So if you would follow Deputy Murphy back into the jury room, we'll get you back out here shortly. Thank you.
All rise for the jurors.
Can we get Mr. Smith in here, please?
Yes, Your Honor.
Do you swear and affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, sir. If you will, have a seat. Get as close to the mic as you can. For the purposes of the court's record, please spell and state your name.
My name is Stanley H. Smith Jr. That's S-T-A-N-L-E-Y, middle initial H. Smith, S-M-I-T-H, comma, J-R, period.
Mr. Smith, we need to talk to you a little bit outside the presence of the jury about exposure you may have had to these proceedings. So I'm going to let Ms. Palmer start with that, and maybe that one of the prosecutors asks you a few questions about it. I may as well, and then we'll figure out what we're going to do next. Thanks for your patience.
Can you tell us what part of the proceedings, this trial that you've seen?
Yes, I actually watched a portion of the cross-examination of Danny Joe. Excuse me. Turn that off.
Yes, please.
Go ahead and just give it to the judge.
Much better that it happened now than when the jury.
You can't unbelieve the courtroom.
I'm stuck. We'll let you slide this one time.
I thought I knew how to operate this.
Hopefully it wasn't someone calling you to tell you what's been going on in the trial. Okay.
Okay, so you said you saw part of the cross of...
I saw a portion of the cross-examination of Danny Joe, whatever that's.
Anything else of this trial that you have watched?
Nothing to watch.
Okay. What else have you heard about this trial since it's been going on?
Well, my wife read me a few summaries of the testimony pertaining to the actual shooting. And other than that, the only thing I kept up with was whether the prosecution was finished and about the recess for the week. And that's all.
I don't have any other questions.
Okay. Mr. Rucker, no questions? Okay. Your exploration with Mr. Smith, Ms. Clark Palmer, is going to have much to do or nothing to do with Ms. Carter?
I can't think of anything I would ask Mr. Smith that would involve Ms. Carter.
Is she someone, I'm not remembering, is she someone named in the will? And if there's controversy around...
She is not a named beneficiary in the will, which is what I was going through in my head too, just to make sure that there was... I can't think of anything that I would ask him that would touch on Ms. Carter.
Okay, and I don't think this is a witness that anyone ought to ask about the circumstances of the shooting. I think we're okay to go forward.
Well, I don't intend to ask him anything about the shooting. I don't know about the state will.
Well, I guess if Mr. McIver talked to him about it, but news reports concerning the circumstances of the shooting seem to be the kinds of things that would not influence what we might hear about. But I should ask you now, Mr. Rucker, I know you don't have questions for Mr. Smith in this area. Any concerns you want to get on the record? No. Let me get this on the record. Mr. Smith, did you know before the trial started that the defense might call you and they alerted you that you were a possible witness?
Yes.
Did anyone from the defense team at any point ask you to do your best to stay away from media coverage?
No, sir.
Okay. I will let you explore what you want to explore with Mr. Smith during cross-examination, Mr. Rucker, if you think any of what we just talked about becomes pertinent. It sounds like, again, we've got some bumping into the coverage that ought not to have happened. Not Mr. Smith's fault, no one told him not to do that, but that doesn't really affect the areas he might be talking about. But if something changes during his testimony, I'm happy to revisit it. So, Mr. Smith, I'm going to have you stay right there. Let's bring the jurors in and start the testimony.
All jurors are present and accounted for, Judge.
All right, you all can be seated. I have complimented you all recently on your continued willingness and ability to shuffle your seating arrangements. I know some of you have some preferred seats because I see certain faces in certain places. And I have also noticed that jurors 38 and 57 sit next to each other an awful lot. But you're moving around in me, so that's okay. We have a witness on the stand who is already under oath because we had to explore a few things with him before you all could come back in. So the witness is under oath. Ms. Clark Palmer, you may take it from me.
Thank you. Mr. Smith, will you tell the jury what you do for a living?
Yes, I'm an attorney at law.
And does your practice, are you in your own practice or are you part of a firm?
Yes, I'm in my own practice. I'm actually semi-retired.
All right. How long have you been semi-retired?
Since January 1 of 2016.
Where did you work before you were semi-retired?
I worked at the firm of Womble, Carlisle, Sandridge, and Rice.
How large is that firm? Just not a specific number of people, but is it a small firm, mid-sized firm, large firm?
I would say it's a large firm, about 550 lawyers.
And how long did you work at Womble Carlisle?
Since 1996.
And your area that you practice now, what is it?
Wills, Trusts, and Estates.
Okay. And when you were at Womble Carlisle, what was your area of practice there?
It was corporate and business law and wills, trusts, and estates.
Okay. And where'd you go to college?
Went to the University of Tennessee.
And then where did you go to law school?
I graduated from Emory University School of Law.
All right. And
I need to know who is making Pop-Tarts right now.
cookies or something.
You guys aren't, there's nothing on fire in the jury room? I just want to make sure there's nothing burning.
It wasn't burning when we left.
Okay, all right. But it's still on. As long as the jurors are okay.
Okay. Do you know Tex McIver?
Yes, I do.
How do you know him?
Well, I became acquainted with Tex in 1975 when I was in third quarter of law school, and I was hired by Mr. Ike Fisher to be his clerk for that quarter at the labor law firm of Fisher and Phillips, where Tex McIver worked.
All right. And have you known Mr. McIver and sort of kept up and kind of kept in touch with him since then?
Yes, we saw each other occasionally from time to time, and one of those times I did wrote his will for him.
When was that?
I'm not exactly sure, maybe in the 80s, 1980s perhaps.
How about,
90s.
and do you know Diane McIver?
Yes, I do.
All right. How do you know her?
Well, when Tex and Diane McIver were married, Tex and Diane came into my office so that I could draw their wills, and I did that.
When was that?
2006.
All right. And you prepared wills for both, at that time in 2006, both Mr. McIver and Mrs. McIver?
Yes.
All right. And I'd like to hand you State's Exhibit 441. Is this a will that you prepared for Mrs. McIver in 2006?
Yes, it is.
Okay. So let me ask you a question about State's 441. Mr. Hyde, I don't need it anymore, sorry. This is good enough. Thank you. So I want to ask you, if I ask you about the ranch or the farm in Eatonton, do you know the property I'm talking about?
Yes.
Okay. All right, so let me ask you about this provision in the will, item 3A, that says that Ms. McIver is leaving her interest in the farm and some other things to her husband. That's what it says, correct?
Yes.
Okay. Do you know how the title to the ranch or the farm is held? What the ownership of the farm is?
At this time or at the time I drafted the will?
Well, let's start at this time. Do you
Yes,
know-
I've seen the deed to it, which I understood to be the current deed.
Okay, and what is the ownership of the ranch?
That's called, they owned it joint with right of survivorship.
Okay. And in one or two sentences, just tell the jury if property is owned as joint tenants with rights of survivorship, what happens when one of the tenants dies?
When a husband and wife own property together, they each have an undivided 1/2 interest in the property. And when there's a death of one of the spouses, the 1/2 interest owned by the deceased is automatically, by operational law, transferred to the surviving spouse.
Okay. Does that happen regardless of what may be stated in the spouse who passed away in their will?
Yes, the spouse that passed away could have said, I want my 1/2 interest to go to Bozo the Clown, and it would have no impact whatsoever, because it's not what they call probate property. And only probate property is affected by the will.
Now, in 2006, did you know what how the ranch was owned between Mr. and Mrs. McIver?
Well, I was told that it was joint with right of survivorship, but I did not see a deed back then.
Can you explain to the jury why this provision is in Ms. McIver's will about leaving her interest in the farm to Claude McIver?
Yes, even though they own the property joint with right of survivorship, her interest, if she were the first to die, would be transferred to her husband. Even though that's the case, we generally put provisions like this in the will to transfer any interest she may have to her spouse, because you don't know if there's some reason that Mr. McIver transferred his 1/2 interest to her after the will was done, and then she died, she would want the whole property to go to her husband, and vice versa. We do it in both wills, and it's just kind of a way of saving the testator's money, because if, say for example, Mr. McIver had transferred his 1/2 interest after they did the wills, they wouldn't have to come back and pay me to make a change to the will. It's already in there. They've already taken care of it. So that's what I did.
All right. Now, you drafted this will in 2006, right?
It might have been, I'm trying to remember the date, it might have been late 2005, but they signed it in 2006.
All right. So now let me move forward to September of 2016. Did you have contact with Mr. McIver in late September 2016?
Yes.
All right. And what was that contact?
Well, I was watching television in the local news one evening, and I saw a report about Mrs. McIver being shot and the circumstances. So the next day I called Tex McIver to offer my condolences and ask him if he needed me to do anything with regard to helping him out with the estate.
And did you become involved with the estate of Diane McIver?
Yes, Tex asked me to be the attorney for the estate of Diane McIver.
And when did you become the attorney for the estate of Diane McIver approximately?
Well, really, I guess, depends on how you want to look at it, but as soon as he said, yes, I want you to help me, but when we filed her will to probate the will in the probate court, that's when I was officially been of record, at least with the probate court.
And just sort of generally, back in that time frame, kind of late 2016, what did you do as the attorney for the estate of Diane McIver?
Mr. McIver had not, to my knowledge, ever served as an executor to the estate, and so I pretty much helped him walk through step by step what the executor needs to do legally after the probate of the will, and to gather in the various tasks he needed to do in order to carry out his duties.
You were giving him advice?
Yes.
And did you do that for free, or were you getting paid to be the lawyer for the estate of Diane McIver?
No, I was receiving a fee for that.
Okay. And what are an executor's responsibilities when they are probating a will?
Generally the person named as the executor in the will is typically the one who will present the original will to the probate court for probate. And what that basically means is it's the court making a determination that this is the last will and testament of the deceased. And after that, the court will issue an order to the world saying if anyone has any business to do with this estate, you have to deal with this person, the named executor. And that named executor would have been Tex McIver in that order. After that, typically the steps taken are the executors to ascertain and get possession or control of all the assets that he or she knows about. They ascertain what are the legitimate liabilities and obligations of the estate. And once those are determined, then you have to go through and decide based on priorities, if there are obligations and liabilities, which there were in this case, which ones are paid first and how they're paid and how you're going to pay them if there's not enough cash. There's just a myriad of tasks in order to carry out the provisions in the will, because the executor is called the executor because he's there to execute what the will says to do. So he starts at the top and starts going down after he's done all those other things. And that's and then after he does all those things, he asks the court to be dismissed.
Okay. And in the case of the estate of Diane McIver, is that part of your responsibilities or part of what you did as the attorney for his estate? Did it deal with the liabilities and the obligations of the estate of Diane McIver?
Yes, I was involved in trying to help him ascertain what were the assets and what were the obligations and liabilities of the estate. But I didn't go out and actually seek out and find them, but he would report to me what he had done.
All right. The cash bequests that are listed out in Diane McIver's will, are those examples of liabilities and obligations of her estate?
Say that again?
The cash bequests that are written out in her will, are those examples of liabilities and obligations of her estate?
No, those are bequests.
Okay.
That's what, if you're a beneficiary under a will, that lists out what you get under the will, assuming there's enough assets left after you pay the liabilities.
Okay. Okay, so separate from that, are there other fees that have to be paid out of somebody's estate?
Well, sure, you have to pay the court filing fees to file the will for probate. There's going to be accountant fees because there typically are tax returns that have to be prepared and filed for the deceased's last final return, as well as possibly you can have estate taxes that are due from the estate, and also you can possibly have income taxes that are due from the estate based on income the estate earns after the death. So there's a myriad, and there can be fees for storing and gathering in all the assets and transferring the assets out to the beneficiaries. There's a myriad of fees and expenses an estate has to go through.
What about the fees for somebody's funeral or burial or cremation? Can those be paid out of their estate?
Yes, that's a requirement that they be paid out of the estate, unless the will provides some other method of it. But yes, that's the number 2 priority the executor has to pay under the Georgia law.
Were your fees paid out of the estate of Diane McIver?
Yes, I assume.
Okay. Well, do you know?
Well, actually, now that I'm thinking about it, the check was from the estate of Diane McIver, so yes, I'd say I did.
And is that allowed under the law?
Yes, that's the number 3 priority.
Okay. So, in front of you, did you review and assist in preparing some slides to help with your testimony here today?
Yes.
Okay. And you have a copy of those in front of you. Could you just flip through that quickly?
Okay. I have.
You have?
I already do.
Okay, and are those the same slides that you reviewed before today?
Yes.
All right, and would these assist you in your testimony with the jury here this afternoon?
Okay, yes.
Okay. Your Honor, I'd like to publish what I've marked as defendants 16 to the jury.
Mr. Rucker, any objections to the use of defendant 16 as demonstrative aids for Mr. Smith's testimony?
No, sir.
Okay, they're admitted for that purpose.
Okay. As you are familiar with the cash assets that were in Diane McIver's estate, or that became part of her estate after she died, is that right?
Yes.
Okay. So can you explain to the jury on this first, well, explain to the jury what is a probate asset, a non-probate asset, what are they, what's the difference between the two of them?
Okay, get ready. The non-probate assets are kind of special assets that even though the deceased owned those assets at the time of her death, they're not included in her estate. And one of the primary examples of that would be a life insurance policy where the deceased named, say for example, her spouse as the beneficiary of the policy. That is deemed to be a contractual matter that those benefits go outside of the estate, and that's one of those special non-probate assets. Another example would be a retirement account where the deceased has named her spouse or someone else as the beneficiary of that retirement account. And again, that would not be part of her estate. That's outside the estate. We would call that non-probate assets. A third example would be any property, real estate that you own joint with right of survivorship. Because as I mentioned earlier, at the time of death, the undivided one-half interest in that property by operation of law vests in the surviving spouse, so it doesn't go through her estate. So those are examples of non-probate property. Everything else typically is probate property.
Okay. So what was the total cash probate assets of Mrs. McIver at the time she died? What was that dollar amount?
Well, when we gathered in the information, we came up with this, it was about $275,000 in the exhibit and $530,000. So that was the cash position at some point soon after the probate was.
And you already told us that the life insurance policy and her 401k, those did not become part of her estate.
That's right. The executor would have no power or control over those assets.
Okay. So you are also familiar with the cash bequests that Ms. McIver made in her will, right?
Yes.
Okay. And so it's on your screen there, but if you could flip to the next page, what was the total amount of the cash bequests in Ms. McIver's will?
$350,000.
So at the time that Ms. McIver died, was there enough cash in her estate to satisfy the cash bequests listed in her will?
No.
All right. Did you provide Mr. McIver advice as to how to raise additional cash to satisfy the cash bequests in her will?
Yes, I did.
Okay, what was that advice?
The advice is that you have to sell some assets in order to raise the cash to not only pay the cash bequest, but the expenses the estate is going to incur.
And in this case, what assets did you advise to be sold?
After we looked over the list of assets, I determined that the assets that probably needed to be sold as soon as possible were Mrs. McIver's clothing, her jewelry, and her furs. She had quite an extensive collection of these furs.
Okay, so why was it your advice to sell those assets quickly?
Well, I viewed her clothing, which was very stylish, one-of-a-kind, very expensive clothing, and for which I understood primarily they were winter clothes. I viewed those assets as what we call wasting assets. It's kind of like if you have a whole bunch of bananas, you got to sell them. You got to sell them quickly or they're going to rot. Well, not to say her clothing was like bananas, but her clothing were stylish clothing. And so to the extent you waited until the next year, they could be out of style and the value would go down very quickly. Secondly, I understood them to be primarily winter clothes, and you're going to get a much better price if you sell them during the winter than if you wait and try to sell them during the summer, especially with regard to the furs. She had 137 furs.
Okay. And did Mr. McIver take your advice to sell the clothing and jewelry and furs?
Yes.
Okay. At some point, was there a claim made by U.S. Enterprises against Diana McIver's estate?
Yes.
And what was do you remember about when that was, when the claim was made?
It was right at the end of December 2016, and the very first several days of January 2017. I think the claim letter was dated like the 31st, and I think we found out about it maybe the 2nd or 3rd of January.
And at the time, what was the amount of the claim against Ms. McIver's estate?
At that time, $975,000.
Okay, and is that what is reflected on the third slide there?
Yes.
Okay. And at the time this claim was made, was there enough cash in the estate to satisfy 975? Well, at the time this claim was received, did the estate have $975,000 in cash?
No.
Was that claim eventually settled?
Yes.
Were you involved in that settlement?
Yes.
Okay. And can you tell us how the claim, the $975,000, was satisfied?
Yes. Once again, it's a little complicated, but when Mrs. McIver died, an intermediary company called DRS had what was called a key man life insurance policy on her life, meaning that when she died, $1 million in life insurance proceeds would be paid to DRS. Now, DRS owed U.S. Enterprises money, so those dollars were transferred to U.S. Enterprises for purposes of helping pay off some of those loans that DRS owed to U.S. Enterprises. And then DRS also assigned a claim it had against Mrs. McIver for $975,000. It assigned that claim to U.S. Enterprises. That's how U.S. Enterprises got to be the one who made the claim against Diana. It just was a transfer from the middle person to the U.S. Enterprises, and then U.S. Enterprises made a direct claim against the estate of Diana.
Okay. And the billboard properties, were those owned by Clay Management Company? Do you remember?
Yes, there was, I believe, 4 billboard properties that were owned by a company called Clay Management, which was owned 100% by Diane McIver at the time of her death, so that was one of those probate properties. So yes, the estate had access to $500,000 worth of billboards.
And
Well, we actually were thinking they were worth $500,000 to $650,000 at that time.
once the ownership of those properties was transferred, were the billboard properties still part of Diane McIver's estate after that?
You mean after they were transferred as a part of the settlement?
Yes.
Yes. As a part of the settlement, the estate transferred those billboard properties, and it was no longer an asset of the estate.
All right. And let me step back to asking you, to go back to when I was asking you about the advice to sell Ms. McIver's jewelry and clothes and furs. Do you remember about when you gave that advice to Mr. McIver?
I'm just kind of taking a guess here, but I'd say end of October, first or middle part of November. It was after we saw we weren't going to have enough money to pay everything and the expenses and all of this.
All right, I have a moment now. Okay. As part of your responsibilities as attorney for the estate, did you make an assessment of the net worth of Ms. McIver's estate?
Well, yes. It was kind of a running total as either assets, the value was determined finally based on sale, or also based on the liabilities and changes in the obligations of the estate. Like, for example, the $975,000 was bolted out of the blue.
When you made the first assessment, do you remember what the value that you assigned to her estate was?
I think it was probably around $3.1 or $3.2 million.
Okay.
That's not cash, that's just the assets.
Okay. And did you share that information with Mr. McIver?
Well, yes.
Okay. Did that number change over time, the net worth of Ms. McIver's estate?
Yes.
Okay. Did it go up or did it go down over time?
Down.
Okay. Thank you, Judge. Those are all my questions.
Okay. It's 5. So, Mr. Smith, unfortunately, for your schedule, we're going to need to stop because our jurors have other commitments and give us a bunch of hours each day and have been for a while. So we're going to reconvene tomorrow at 9, and we'll be having back here at that point because the state may have some questions to ask on cross-exam. Between now and then, please don't discuss your testimony with anyone, and do your best to stay away from any media coverage of the case. Okay? Okay. All right. Would you estimate, good faith estimate, that you all would be resting tomorrow, or you'd be resting Friday, or we should talk, or what's your current forecast? And I'm asking the jury just so they can get a sense as well. Friday? Okay. I'll talk more with the attorneys. They can speak more freely about their expectations and whatnot. I've got a list of potential witnesses, and that doesn't seem like an unrealistic estimate on the defense part, that they might be, and they're not committing to it because they don't control cross-examination, they don't control when we have to take breaks to work through legal issues. But it's looking like Friday would be when the defense would rest, and we'd be at one of these break points where we need to figure out what's next. I'll keep you posted as we learn more, and if after we talk for a few minutes, it seems like that estimate ought to be changed, I'll tell you in the morning. But for your planning purposes, look forward to at least the rest of this week as time together. Between now and tomorrow at 9, enjoy yourselves. Tomorrow is Thursday, based on your claim that today is Wednesday. So we'll see you Thursday morning, a little before 9 a.m. Thanks again for all that you're doing. Don't talk about the case, no outside research. And we'll see you then. Any logistical questions at this time? Great. Thank you. See you in the morning.
All rise for the jurors. Please be seated.
Mr. Smith, I think you're free to go. You don't need to stay there anymore. But we'll see you a little before 9 tomorrow, please. Thank you so much. We've got a couple of questions. One, I think I'm remembering the name correctly. Who was Mr. Watkins? Attorney who...
Watkins.
Yeah. What was his connection to the case?
He was also an attorney for the state.
Okay.
He was like litigation counsel. Once the claim got made,
Okay.
he got brought in to handle the litigation.
Okay, because I met him and it was relayed to me that he was the lawyer for the estate. And
more than
He
once.
is not Mr. Smith, he's
Right.
someone different. Okay, that helps me. For scheduling purposes, both Mr. Robinson and Mr. Gardner are expected to testify? Okay, and not so much timing, but as I'm working through, you still have left. Obviously, there's Mr. Culver, not a bite-sized witness. And then I understand Mr. Gardner. Mr. Robinson will not be cumulative of Mr. Gardner?
No. So that's why I said,
Okay,
he very well may be.
okay.
And
I trust you'll manage that in a way that doesn't frustrate the jury. Okay,
I got it.
great. And then I see Ms. Anderson's name. There's obviously anyone from the state's list. Are there, besides Culver, Gardner/Robinson, are there witnesses who would take a long time?
Annie may take a while. Annie Anderson may take a little while.
Go ahead.
Let's go Ted Smith. He's not on the list. I could get you a new one.
Mr. Ted.
Mr. Ted. Mr.
Had there
Ted.
been fewer hearsay objections, we wouldn't be having this debate. That's the price they pay.
There are consequences for actions on both sides. All right, Mr. Ted. Okay. Anything from the defense that we need to work through at this time?
I'm filing a little short brief tomorrow morning on this issue dealing with count 5.
Okay.
And I may raise something else in the morning, but we'll do take a break dealing with the rulings. We'd like
Well, rulings.
direct a verdict motion.
Okay.
You actually anticipated it, that the consequence of not having severed, despite our promise that this is exactly what would happen, and the state's assurance that it wouldn't happen, and it did happen. So now we have, I think you know what I'm talking about.
Okay.
Now we have Black Lives Matter talk about, ad infinitum, and none of it was admissible, none of it was relevant, because that count never should have been a case. I made that argument.
Okay,
But-
and you may renew parts of it, I got you. Okay.
And I'm interested in when you're thinking about doing a charge conference, assuming we rest Friday morning. My understanding is they've got a short rebuttal, am I misunderstanding something?
We're going to talk about rebuttal in a minute, but the charge conference needs to be before closings. And so the way that could work elegantly, which isn't how a lot of stuff has worked out so far in terms of how we've been working with the jury, if we're done with all the presentation of evidence at some point on Friday, we could do it with what remains on Friday, so that Monday could be getting into closing. But I can't answer that yet till I know we've got a time on our hands where it makes sense to let the jurors go. So it could be that you all rest late on Friday, and we would do it then, even though we haven't had the rebuttal yet. If it doesn't make sense to start the rebuttal with what time remains on Friday. But I'm ready. I also don't think it makes sense to use up your lunch break on that. But you could take a team vote on the defense side. I just don't want protein bars thrown at me during the charge conference. Don't want that either. Okay, the rebuttal case. Some of it is reactive to what may not have happened yet. But I know that there is Dr. Borderman out there, theoretically. Hopefully you guys will think long and hard about whether that's necessary in light of how Dr. Rye went. We have the jury view that we need to sort out, and we'll be able to sort that out after Mr. Gardner/Robinson, after they've testified. And then there may be whatever else you all think is appropriate on the rebuttal side. Based on what you've heard so far and what you expect, hopefully there aren't a whole lot of surprises from the defense witnesses. How long are you thinking rebuttal would be? Is it less than a day?
Yes.
Okay. All right. Anything on the state side that you want to flag for me? Sounds like some briefs from Mr. Samuel will be landing tomorrow.
Yeah, I look forward to them. I disagree with the relevant part, but I'm sure we'll get a chance to articulate that.
You will.
No, you flagged the jury view, which I know just will require a small bit of coordination, probably a little heads up for some folks who might be involved, and so as much of a heads up as we can get about that would be helpful.
Okay.
I'll speak with the defense attorneys about scheduling for their witnesses to make sure I have my experts here at an appropriate time. So I think everything else can be dealt with outside the presence.
I'm happy to finalize the jury view, it's happening or it's not, and the logistics of it, if it is, once we've heard from the pertinent defense experts, then in a break, we can talk about that. So I'm not intentionally leaving you hanging, or I am intentionally, but for a good reason. We'll hear from them. Okay. Well then, I'll see everyone a little before 9 tomorrow, and we'll pick up the cross-examination of Mr. Smith. When he's done testifying, we'll see who's next for the defense.
Yes, sir.
Thank you.